So if you recall from the last class, I mentioned that President Buchanan, who was elected in 1856, had said at his inauguration that now that the Supreme Court was going to hear this case, the issue of slavery in the United States would be, quote, steadily or speedily and finally settled. And this is the case he was speaking about, Dred Scott v. Sandford. It turns out that this case obviously didn't settle anything. It only actually caused more issues for the United States, and very quickly set us on a path that dredged us into a civil war. So let's go ahead and spend some time with this case, because the factual setup is important. And then what the Chief Justice writes, Chief Justice Haney writes the majority opinion in the case. What he writes is also important, because it sets precedent that really is troubling. So to say that this is the worst case ever decided by the Supreme Court would even downplay the effects that it has. Nearly every constitutional scholar would list this in the top three cases that were the worst cases that the Supreme Court has ever decided. And it puts a sort of black eye on the court and really threatens the court's credibility within the constitutional system of government that we have. So its legs are long, so to speak. So what are the facts in this case? Well, Scott in this case was a slave in the state of Missouri belonging to an individual by the name of Emerson. In 1834, Emerson travels and takes Scott and Scott's family to Illinois. So in 1834, Illinois was a free state. So Emerson takes Scott from Missouri to Illinois and crosses state boundaries into a free state. In 1836, Emerson takes Scott and his family to Fort Snelling, which was a military base outpost in Wisconsin. And Wisconsin at that time was part of what was known as Upper Louisiana because of the Louisiana Purchase. And at that point in 1836, this territory was free based upon the Missouri Compromise. In 1838, everyone, the Emerson and his family and Scott, all returned back to Missouri, which was a slave state. In a short time after 1838, Emerson dies, and Scott and his wife and two children were sold to an individual by the name of Sandford. And so in this case, you'll see on the slide, I have it Dred Scott v. Sandford. If you were to look it up, it would be Dred Scott v. Sandford, so Sandford. And the reason for that is in the bill of sale, they misspelled Sandford's name wrong. So that's all that you need to know. And as a caveat, Sandford was a resident of New York at the time. So in 1846, Scott files a legal suit in a Missouri state court. And he asked this court to declare him and his family free based upon their stays in free land, that being Illinois and Wisconsin. The lower court, the court that Scott first forces his claim in, sides with Scott. But the Missouri Supreme Court ultimately strikes it down, holding that while Scott may have been free in those free territories, the laws there do not apply in Missouri. And so since Scott was residing in Missouri when he was sold, he still remains a slave. 10 years later, in 1856, Scott files a new suit. And this time he files suit in a federal court claiming the exact same premise that he did 10 years earlier, that his stay in the free lands of Illinois and Wisconsin functionally made him free in Missouri. Sandford files a motion. So the individual who currently owns it files a motion claiming that the court lacks jurisdiction to hear the suit because Scott's not a citizen. And what he's claiming there, and really what the issue in this case is that Sandford is claiming that Scott is not a citizen of the United States. And if he is not a citizen of the United States, he can't bring suit in federal court to force his claim. Uh, so the main issue, the primary issue in this case, and I call it primary issue for a very important reason, because Chief Justice Taney, in his majority opinion, goes on to speak much more broadly than the issue in the case. But the issue in the case is whether or not Scott, and more broadly defined, African Americans, slave or not slave, are citizens of the United States. Well, the Supreme Court decides this case in a 7-2 fashion, where Chief Justice Taney writes the majority opinion. It's important to note that all of the other judges in the majority wrote their own opinions, and none of them signed on to the majority opinion that Chief Justice Taney wrote. There were two dissents, and I bring them up because one of them is fairly important. So there were Justices McLean and Justices Curtis who filed dissents. Both of them were well-known abolitionists. So they wanted to see the institutions of slavery stripped down. But as an important side note to this, Justice Curtis, his brother was the attorney for Scott. So as you can see, we've covered this a few times. This is a clear conflict of interest, and Curtis should have recused himself in the case, and he didn't. And the reason for that is only the justices themselves get to decide when they have to recuse themselves. And Curtis, in this case, does not recuse himself from the case. And as I said, Scott is represented by Curtis's brother. So to turn to Chief Justice Taney's majority opinion. Chief Justice Taney is widely held as the author of the worst decision of the Supreme Court for a few reasons. First, the language that it uses. And second, because he takes an action that is relatively unheard of and significantly frowned upon by jurists. And that is, he answers questions that are not posed to the court. So the question that was posed to the court was whether Dred Scott and African Americans, slave and not slave, are citizens of the United States. That's the only question that is posed to the court. But Chief Justice Taney answers further questions, which is what is known as, in Latin, sua sponte. Sua sponte simply translates into issue discovery, which means that the court, in this essence, discovered a new issue that it needed to answer. Well, courts, and especially in the United States, there is generally understood to be a significant prohibition on courts weighing in on issues that aren't brought to them. And the reason for that is our judicial system is responsive. A conflict comes to them, the court rules, or a court rules on the conflict. Well, Taney does that. Taney and the majority does rule on the conflict in this case, but they also go much further. So let's just handle the first part. Is Scott a citizen? The Supreme Court decisively says, no, Scott is not a citizen, and as a result, he cannot use the federal courts. The majority, such as Chief Justice Taney, says that no member of the African American race can be a citizen of the United States, not even blacks who have lived in free states, and not even those who had never in their lives been slaves. So individuals who had been residing in the United States had been free their entire life. They were not citizens either. And the reason for this is Chief Justice Taney looks at the Constitution at the time it was enacted, using what we largely refer to as original intent interpretation, and sees that the Constitution, or at least claims that the Constitution, does not recognize African Americans as citizens of the United States. And that despite the broad language that was used in the Constitution and also the Declaration of Independence, none of that was intended to apply to African Americans. And as a result, since it didn't apply when it was written, it doesn't apply now. They argued that the Constitution must be interpreted as originally intended and written, and changes in public opinion do not change this. The court according to Taney, must not falter in the path of duty. Chief Justice Taney goes a step further and distinguishes between citizens of the United States and citizens of states. And he argues that some states may give African Americans citizenship within their state, but that does not mean that they have citizenship in the United States, because no African American, slave or free, could ever be a U.S. citizen. So the court concludes that Scott is not a U.S. citizen, nor is he a citizen of Missouri, since it was a slave state, and therefore he's absolutely not entitled to sue in federal court, and the case should be thrown out. Now, as that would be a horrible place, or that would be a horrible decision if the case stopped there. Like, that would be enough. And Chief Justice Taney should have stopped there, because that answered the question that was posed to the court. But Chief Justice Taney does not stop there. He goes on, and the reason why this case has legs is because Chief Justice Taney went on. He goes on to answer another question that was not at all briefed to the court, and that question is, was the Missouri Compromise constitutional? And the answer that the court gives is no, the Missouri Compromise was not constitutional. It was an unconstitutional act of the legislature. And this was only the second time in the history of the United States Supreme Court that the court invalidated an act of Congress, the first being Marbury versus Madison 54 years earlier. And the reason for this, the reason why Taney and the majority believes this, is they state that the right to own slaves as property is guaranteed within the Constitution. Now I'm going to move into some quotes from the opinion. These quotes are horrific, but to understand the monumental nature of this decision, you have to wrestle with what Taney wrote. Taney says, the Negro might justly and lawfully be reduced to slavery for his benefit. He was bought and sold, treated as an ordinary article of merchandise and traffic whenever a profit could be made. This opinion was at the time fixed and universal in the civilized portion of the white race. So his argument, in essence, is that this law, this Missouri Compromise, which allowed states to enter in as free states, or mandated that states entered in as free states, was unconstitutional because at the drafting of the Constitution, at that time period, in that original intent, African Americans were absolutely not thought of as citizens, and they were only thought of as property. And so the intention of the founders was never to have African Americans become citizens of the United States. That's a fairly significantly debatable point. As we've covered in this class, the founders were not uniform in their beliefs in any sort of way. And there were noted abolitionists among the founders. John Adams being amongst them, one of the archetypes of the Constitution. But according to Justice Taney, slaves are property, and they're nothing more than property. And Congress, because of the Constitution, is unable to interfere with property rights extending to slaves. He goes on to say that the only power conferred on Congress is the power coupled with the duty of guarding and protecting the owner in his rights. That is, the slave owner's property rights under the Fifth Amendment to be protected from due process violations. Since the Missouri Compromise prohibited slave owners from continuing to be a slave owner if north of a certain line, it violated due process and thus was unconstitutional. This was an issue for the states and territories to decide, not Congress. And so that states could decide to be slave or free, but Congress could not mandate it. And so when Scott and his family traveled to free territory, that territory wasn't free because the act upon which that territory was free, the Missouri Compromise, was unconstitutional. And so that Dred Scott actually never resided in free territory because those areas weren't free because it was a federal law that mandated it. That whole second part, entirely unnecessary for Chief Justice Taney to weigh in on. The case was already resolved with the answering of the first question concerning citizenship. But by negating the Missouri Compromise, which, by the way, had already been repealed by Congress. Remember, the Kansas-Nebraska Act of 1854 repealed the Missouri Compromise. What he did is, Chief Justice Taney, is he negated any sort of rights of African Americans or freed slaves, etc., that existed from 1820 to 1854. So slaves who were freed in that time, from 1820 to 1854, were no longer free because slavery was unconstitutionally removed from those territories. So those two judges in dissent are quite angry. They argue that, first off, the Constitution was ratified for whites only. That the argument that the Constitution was ratified only for whites only is a huge assumption made by the majority. In fact, they cite members of the Constitutional Convention who were very clearly thinking and arguing about the document as it turns to protecting everyone, not just whites only. They even argue that amongst the founders, the idea that African Americans were, quote, not agreeable members of society, while it was a majority opinion at the time, it was not the only opinion at the time. There were numerous individuals who we would consider founders who saw that view as exceedingly distasteful. And so what it boils down to is that assumption is more a matter of opinion than law, because there was no uniform belief of the founders at the time the Constitution was written. Those in dissent go on further to argue that since owning slaves is now considered an act of piracy in the open seas, remember, Congress has invalidated the slave trade, so individuals who are caught trafficking slave on the open seas are in violation of law and are in essence pirates. Why would the court be arguing about original intent when very clearly the situation had changed? Arguing original intent is all well and good if society has not moved forward, but their argument is that society has moved forward. They decisively put their foot down when they say this in conclusion, that all slavery of any person has its origin solely in power and is always against what is right. But they don't win the day. So this is a 5-2 majority opinion that not only states that African Americans have never been citizens of the United States, but goes on to negate the Missouri Compromise and therefore throw a lot of settled issues that had taken place from 1820 to 1854 into basically limbo, and created a sort of societal cooking pot, which very shortly after this case is decided, ultimately boils over.